Okay. Welcome to all of you, those present on my screen, but not only those, but all the people, and there are many people of you hiding behind their tags, their name tags. Welcome. Well, we just heard a terrific speech of Mrs. Professor Ruiz Fabre, and I think that was a very motivating start. And we just continue with a couple of those topics that she covered, and to go deeper in that as well. So yeah, when I started to prepare yesterday for this panel, uh, yeah, I was pleased to find that a number of the papers were very, very interesting, and they all matched each other in a significant ways, in a number of ways, and it was very intriguing to see all those connections. So I will not speak any longer myself, in order to give the speakers the time that they need. I have promised the organizers to be very strict in the time, 30 minutes each, which means that it's approximately a quarter of an hour for the presentation and a quarter of an hour for Q&A. So I will not take any longer and telling the audience what they can tell much better themselves. The first speaker today is Professor Gleider Hernández. He's a professor of public international law at the KU in Leuven, and also I learned at the Open University in the Netherlands. Professor Hernández is a distinguished academic, but also holds extensive practical experience. He is currently, among many other things, member of the board of the European Society of International Law. He is an editor of a number of journals. I will not tell all these journals because then time runs out before he starts talking. And despite all this, and I think rather surprisingly, he also found the time to learn Dutch, I read. I think that is in no doubt a more challenging enterprise than speaking about the indeterminacy of law. You present a very, well, I read a very interesting paper, Professor Hernandez, so I haste to give you the floor.
Hartelijk dank, Professor Westerman. And yes, Dutch, I work at a Flemish university, so I thought it really important to do my best to learn the language. I'm also married to a Dutchman, which I think provides an additional incentive. But I live in French-speaking Brussels, so maybe I'm not doing enough. Anyhow, but thank you for the very generous introduction, and I hope to keep the time, although I realized that I got a bit ahead of myself in preparing the paper that I've sent over, and maybe we'll need to be judicious and only focus on certain parts. But my paper is on an aspect of international law that opens up spaces for interpretation. And to me, that is the notion of indeterminacy. And indeterminacy is a broad legal, but also conceptual concept that I think opens certain questions. And I think these are questions that are being addressed in different ways here. But I've allowed myself to take off my experience from practice and ruminate a little bit in the high clouds of theory. I'm no philosopher, I am a lawyer by training, but I've always been interested in the wider questions of what makes law law, what makes international law a legal system, and what place various actors, and in particular judges, play within it. And my argument that I'll be presenting to you today is that international law's indeterminacy opens up spaces for interpretation. That space that opens up for interpretation, I am calling, and my working title is evolving towards, the determinability of international law. And in turn, that raises questions as to determinability by whom. And one concept that, for a number of reasons, I'm still trying to fully articulate is that determinability aspect is an official role being played by so-called systemic officials. And I draw from a number of authors in this respect, and that won't be the subject of this piece, but in essence, that international law contains with it the seeds for its own determination, the institutions and actors that are endowed with authority to interpret and determine the law, and in that sense functions as, in a grander sense, I mean, perhaps I shouldn't be invoking sociologists, but that international law in turn becomes an autopoietic or self-closing social system. So basically, I will present the following very brief arguments. I want to first talk a little bit more about this indeterminacy and the potential for determinability. Although I think there's been a lot of academic writing on indeterminacy, much of it has been focused on Koskiniemi's thesis on radical indeterminacy. And I think there is merit to this argument, but it's not one to which I subscribe to in full. In fact, as I've mentioned and alluded to a bit earlier, my argument is that legal systems are not condemned to incoherence, but rather contain mechanisms and institutions through which we determine meaning, and that go well beyond the bounds of language, but also into the realm of institutions and social actors. My argument in that sense is, simply put, that the legal system empowers law-applying actors to exercise discretion within bounds and take law-creative measures that may not be informal, but that are substantive. That these in turn go through a process of acceptance as authoritative, not necessarily binding, within the legal system, and that authoritativeness demonstrates a self-empowering dimension in filling vacuums of indeterminacy. And thus, for me, interpretation is linked to wider questions of authority within international law. And there, as part of some wider research that I'm trying to do, I think it is important to think about this beyond the analytical jurisprudence that applies primarily to domestic legal systems, and that we must be thinking more creatively about how authority structures exist, are constructed, are crystallized. So to give one example that I'll come to, why are judges, especially those of the ICJ, widely regarded as authoritative actors, even though they are only subsidiary lawmakers, but also other actors like the International Law Commission, or even groups of experts working within specialized bodies such as the World Health Organization or the Food and Agriculture Organization. You know, what dimension gives them authority, and is it sufficient to just assert that they have it and move on? Or must international law develop an endogenous theory of this? So in that sense, I think before I go on, I just need to briefly outline that if we are to think about concepts of authority, we need to understand what we're talking about. And in this sense, I separate authority from legitimacy, from persuasion, from power. And I think there it is important to maybe define terms a bit more formally. And I hide behind Joseph Raz, not an international lawyer, but who situated authority as an aspect of, as an ability to influence conduct and behavior, going well beyond persuasion on the merits or contents of what is being said, but rather through content-independent authority. And so I'll conclude with that on this notion of content-independent authority and who holds it, and develop that argument, time permitting, as I already see that only my introduction has taken a bit of time. I just want to say one last thing to just get the frame fully set. To get the frame fully set before I turn to this. And that's basically, what are the foundations of that authority? And in that sense, I was inspired by Professor Ruiz Fabri's discussion about interpretive communities. And to that, we can also talk about different practice and epistemic communities, slightly different concepts of that describe a community of legal professionals. But essentially, I think we find in international law a blend of common discourse rules, common technical and conceptual vocabularies that define us, portray us, and depict us as experts, as well as processes of recognition within the profession through which we endow, if not formally, but in substance, special groups and special categories of actors as having a sort of systemic function. I'm leaning towards calling them systemic actors rather than systemic officials, because official status comes with, is a loaded term, at least in domestic legal theory. But this is a concept that I'll probably be defining in, if not in this paper, in a future paper. So anyway, my first point is essentially on determinacy. And this is an argument that I think has been exploded for quite some decades about whether law and legal systems remain determinate, with rules of interpretation limited to hermeneutic or cognitive processes of objective discovery and identification, versus those critical arguments that have challenged this squarely. And I think it's important to kind of distinguish between the two, because if one takes the possibility of indeterminacy seriously, and the partially constitutive character of an active interpretation of a process of interpretation, then a question arises. If law is indeterminate because its commands are conveyed through a language, through concepts that are themselves indeterminate, then where does that leave the role of the lawyer and what we can do through determinacy? So throughout 20th century legal scholarship, both domestic and internationally, theorists have sought to resolve indeterminacy through various systemic principles. Obviously, in international law, it is our famous Article 38. And if we read through the travaux préparatoires of the ICJ, PCIJ statute very carefully, we see in essence this abhorrence for vacuums, this fear that the court might not be able to resolve disputes through law. And it is that fear that has animated so much of dispute settlement throughout the 20th century, and dare I say, also that has helped to impel, spur, and develop notions such as, should we have rules of interpretation? Should they be limited to treaties or also extend to unwritten acts and practices? Hence the topic of this presentation, the topic of our host's ERC grant. And I think these raise important questions about the nature of international law. In exploring these questions of the determinacy, obviously it's been seen as a problem through which mechanisms need to be developed in order to close them. And in essence, that's where this determinability thesis for me arises. We see it in the work, for example, of Hans Kelsen, who basically is prepared to concede the intentional indefiniteness of acts, but argues through his pure theory of law that we have that acts of interpretation are basically, how can I put it, acts of will or cognition of choices. And it's there that his concept of a frame comes into play. The law provides a frame within which certain acts, certain will, and certain choices of certain actors can close those gaps always within the system in a basically recursive relationship. And thus, in his theory of judicial decision-making, individual application by these systemic actors determines and constitutes general legal rules. What's interesting is that we don't really accept this within international law. We accept the potentially subsidiary character. We accept that judicial decisions operate as means for the determination of rules. But we do not even concede the role of judicial institutions or other potentially lawmaking organs as being systemic. And I think that comes from anxieties about what kind of legal system international law is meant to be. Is it a treaty-based system under the UN Charter, Charter über alles, or are we speaking of a fully fledged autonomous legal system that is qualitatively different from domestic legal systems? In essence, though, but returning quickly to Kelsen, his solution, and this is something that is joined by Herbert Hart, was to reserve a place for the exercise of discretion for legal officials. And this is something that has come out in much domestic analytical jurisprudence, this idea that whatever indeterminacy might exist in the interstices of the law, forgive me, sorry, there's an ambulance going outside, it's slightly distracting, but essentially, the legal system contains mechanisms and institutions to render the law determinable at all times. And this is something that's shared throughout these mid-20th century traditions. This, what I call the sort of modern legal positivist view, although obviously scholars that are not necessarily positive accept this. And that's juxtaposed. It was in the context of this sort of frame that Koskiniemi's radical indeterminacy thesis has arisen. In 1990, of course, or 1989, excuse me, with the publication of From Apology to Utopia, the entire book on the structure of legal argument was premised on this notion that law is radically indeterminate. With that comes a refutation of international law's claim of objectivity and the embodiment of universal values. And through the oscillation, through the potential maneuvering between consent and justice, which are his ascending and descending arguments, the oscillation generates in turn for him indeterminacy and creates a space for politics, all the while channeling the form in which international legal argument is made. This is, in some respects, a precursor to his later discussions on the culture of formalism, that international lawyers are supposed to adopt. And I mean, there are widely diverging views on what this culture of formalism entails. I have had arguments with scholars far more senior to myself who know Professor Koskiniemi better than I, who've told me I'm just wrong. But my understanding has traditionally been that if you have this space for indeterminacy and it is bounded by the nature of argument and by the nature of language, that in turn, it is perhaps not so radical at all. And although we might find a partial refutation of the determinability of law, what we find instead is a recognition of the grammar and technical vocabulary that international lawyers must master in order to make their arguments understood. And that if there is any ontological indeterminacy in the law, it is in fact moving beyond that into a social critique, into an institutional critique, that we find the answers about basically who is empowered to use the law, who gets to use the law. And my argument, and I think I'm going to have to jump ahead a little bit here, and my argument is that indeterminacy is not so much radical, but opens up a space for discretion. And that discretion is then applied by law-applying authorities who claim this authority, who develop this authority through various substantive and procedural mechanisms, going from citation to precedent to employing a certain mode and vocabulary of reasoning. And so rather, to me, the question is, interpretation is not about the indeterminacy of law, but about who has the authority to interpret and apply the law, which I think will be a discussion that will be undertaken by several of the rest of the panelists today. I already see that I've been speaking for almost 18 minutes. I've got only to about page 7 of my paper. Professor Westerman, do I have a couple of minutes to speak a bit more about this?
Because I happen to notice that they're 4 minutes later. We started 4 minutes later. So yes, you have. Okay. Well, then I think I will advance, let's see, I think I will just advance an understanding of this concept of authority. And with that, with those 4 minutes available to me, just basically lay that out and then perhaps open up to questions after that. So in essence, if there is such a thing as interpretative authority, and it is exercised through the application of rules, through the application of law in such a way that law is created, well, what do we mean by this? First, I think we need to distinguish the notion of interpretative authority from authoritative interpretation, which in its most classic sense is basically a relevant expression of consent where parties endow or delegate to an organ or to an institution the power to interpret, or the competence to interpret. That's something different than what I'm talking about. What I'm talking about is more the social phenomenon that undergirds law. It is about the actor's capacity to command recognition in discursive practices from interpretative claims. And in this, I think I find common cause with Ingo Venska's concept of semantic authority, which of course is premised on the use of language. But basically, in so doing, if the actor is able to command recognition, then they are capable of establishing their own statements about the law as reference points, as these reference points that condition future discourse, as well as settling present disputes. So social practice in this sense both legitimates a prior claim to authority, but also reifies the power of the interpreter going forward. So in that, I've alluded to it before, but I'll go through it very quickly. But I think it's important to separate a notion of content-independent authority from power, which is the ability to coerce behavior without the person or the actor, the addressee of a rule wishing to do so, and a more persuasive aspect where, although we're certainly not bound by an interpretation, we can be convinced by the merits, the content, and the substance of what is being argued. And to me, authority falls somewhere in the middle. It is a willful, so to regard an actor as authoritative or an official as authoritative is to defer to their judgment, even if there may have been disagreement, but also, and I'm borrowing from Herbert Hart here, to internally adopt a sense of compliance. So there is a presumption that if this authoritative actor presents a view, I may not be inclined to agree with it, but henceforth, I will accept it as the correct view.
and I will incorporate that authoritative interpretation in the way that my future practice will manifest itself. And I think that that's probably a better way to describe the way that states and the way that other international actors do internalize the decisions of certain systemic officials, systemic institutions like the Security Council, of course. I'm trying not to just refer to courts all the time, but to the Security Council, to the findings of the International Law Commission, I'm trying to think to the decisions of other expert-making groups and so on, to the point even, and maybe I'll end with this provocative claim, that we find ourselves with think tanks of academics, think tanks of practitioners, aping and mimicking the processes of the ICJ, the ILC, in order to claim authority for themselves. And many of you might be aware, for example, of the Tallinn Manual 2.0 on cyber operations, which was essentially a group of self-nominated academics funded by NATO, who then consulted 50 states, to be fair, and came up with a proposal that suggested this is the Lex Lata on cyber, and then gave it to all the foreign ministries in the world, and then get cited widely and widely and widely. But here we find a de facto claim to authority, in many respects, by mimicking the practice of the International Law Commission in terms of deliberation and drafting. And the reason I say this is because I was a member of that expert group, and serving in that expert group was a fascinating experience in how process in turn feeds authority or feeds claims to authority. But now I realize that I am really out of time. So I think I'm going to end on that. And I'd like to raise questions. I realize my presentation probably raises more questions than it answers. And I admit that I am struggling with fully conceptualizing these, but at the same time, I cannot resist but find this a fascinating and enduring question about the nature of international law, about what makes us international lawyers, and what makes our discourse autonomous, unique, and relevant. Thank you all for your time.
Thank you, Professor Hernández. We will clap virtually. Thank you for this interesting contribution and your view that I think it was a very eloquent defense of the view that authority is somehow dispersed throughout the entire interpretive community. I think intriguing in itself, and I'm sure many people would like to react. Please then push the Q&A button. You can also chat, but that means that I have to read the two things at the same time. And since I'm rather old, I'm very bad in multitasking. Yeah, there is this question by Kostya Gorobec, who thanks you for the presentation and says then, I will read it aloud. Speaking of the concept of authority, you seem to link it to actors, international state officials, etc. And you suggest that the issue of interpretation is not so much or not only the indeterminacy of the international law, but who gets the authority to interpret it. Would you be open to the idea that authority is primarily the quality and the dimension of the law itself, whereas officials are in this way of secondary relevance? So then it would be put the focus on the authority of the rules, of the standards, I add myself, instead of the actors. But the last is my own, yeah, sorry.
Thank you, Dr. Gorobec. This is the question with which I've most struggled. And this is a question on which I've had various debates with a number of scholars where there is disagreement. I mean, there is an argument, and I think in its modern manifestation, it comes from Joseph Raz, that authority is a legal quality to be found within the substance of the law itself. And ultimately, questions of authority can always be reduced to legal endowment of competence and the legal system's ability to follow these rules. And I don't agree that this is even how it happens in domestic legal systems. And given our more decentralized institutional and formal structure in international law, I think that we must be open to studying, as lawyers, what I'm calling more and more de facto authority. And I guess that was the term I tried to avoid in the presentation, but I just can't avoid it. What I'm trying to argue is that alongside authority of the law itself and authority within the law, we as international lawyers must also be open to how to study and cognize de facto authority. And this is I keep coming back to your question, but I keep coming back to the conclusion that it is incomplete given the nature of international law as I understand it. And obviously that's something that, you know, is open for dispute and for discussion. But I feel that our system does grant de facto authority to a great number of actors, and that thus the answer can't really be found only within the law itself. We can find a formal answer, but not necessarily, in my view, an accurate answer.
Is it your view that it cannot be found only in the law, or that it cannot be found in the law at all, because it is dispersed through the entire realm of the actors?
Thank you. That's an opportunity to clarify. No, it's my view is not that it cannot be found within the law at all. I think the law is both a form and an instrument to generate authority. And I think it's incredibly useful for us to look at it as lawyers and to question that role. But I think that it is also found outside it, and that looking at the social practices, at the epistemic community of international lawyers, in turn helps us to understand how the law is used. And so one of the things that I don't do, but with scholars that I've been working with, and we've been developing ideas together, some scholars have been looking at the way that the law is used to justify certain political decisions, the deployment of drones, or a military intervention here, or, you know, a sanction there. And there, the use of law as an instrument is itself a call to the authority of the law. But then the question arises, to what end? So I think these are studies that can be done valuably together. I do not say that de facto authority is the only way to go, but I think it's a valuable counterpoint to looking for authority within the law itself, if that makes sense. Shall I answer directly Odrefino's question?
The second question about
Yes.
the hierarchies. Are you working with a sort of hierarchy of actors, is Odrefino asking?
Well, no, but yes. I think the unspoken question in a lot of what I do is about upending the formal hierarchy of norms and giving more prominence to organs of international organizations. I suppose particularly judicial institutions. That was my first love. That's what I did my PhD on. And I still tend to write far too much about judges. And I think judges in that sense are very much live in my mind. But I don't think it's pretty, okay, so a couple of things. I do not think it is useful to come up with a new theory of sources, because for 120 years now, we've been discussing whether our doctrine of sources reflects the reality of how they're applied today, but there is very little will for re-theorizing those sources, and I think that's all right. The reason I think that that's all right is that that hierarchy of sources, or doctrine of sources, is part of that vocabulary that we international lawyers use. And we understand each other when we're able to basically master that use of sources. So a very typical pedagogical example, I suppose, would be moot courts and the way that we train students not to cite to certain categories of sources and to focus exclusively on other categories of sources. And we inculcate in them a sense that certain sources matter and certain sources don't. And that is part of your training to be an international lawyer. I think rather than focus on the outcome of that training, my research tries to focus on the process of that training. What are we saying when we inculcate that these sources matter, these sources don't? This process of interpretation works and this process of interpretation doesn't work. Whether you're a critical international lawyer or a positivist or a natural lawyer, we all recognize an argument that doesn't adhere to the canons of international legal argument when we see it. And it is that process of recognition that I think contributes to our understanding of authority as a distinct concept from legitimacy or from legality in that sense. So I hope that answers your question, Ms. Fino. But basically, yeah, I'm not looking for a hierarchy of actors, but I am thinking of identifying processes through which those actors manifest themselves. And obviously, if this research on the systemic officials direction kind of crystallizes, there might need to be some sort of typology. But I am not trained in empirical skills. I'm not good with them, and statistics frighten me. So I don't know if I'm going to take it in that direction.
That is a very tricky thing to say when you are dealing with de facto authority. But then the next question is by Anna Venturato, and I think I have to read it aloud because the attendees are not seeing these questions. I was thinking during your presentation of issues of representation and legitimacy in this context. Can we recognize such authority to determine what the law is to actors and institutions that are often not representative in terms of legal systems, geographical representation, gender representation, etc.?
Mm-hmm. Well, now you're inviting me to put on a very radical, critical legal theory hat on. I think, okay, so here's what I'm going to argue. I'll try to keep
it short.
Sorry?
Yeah, there are many questions, so keep it short.
Okay, I'll keep it short. Okay. Part of what I seek to do is descriptive in order to identify the fact that we endow authority or we recognize authority to institutions and to processes that are not necessarily representative, diverse, etc. If anything, in some of my other writing, I call out the Eurocentrism, the intellectual Eurocentrism of the way that international lawyers think, and the fact that it doesn't only fail to correct the past, but also constitutes and creates the future. But in this sense, the first stage of my project is descriptive. It is to identify elite structures. It is to identify authoritative actors. Then in the next step, those with political agendas can step in and call out the lack of representation, whether it is gender, geographical, cultural, religious, etc. I think that the mapping exercise is in itself valuable, both from a theoretical lens and from a more politically activist lens. Then I guess I'll just jump straight into the Marquesa Pinto's question. Would you like me to read it, Professor Westerman? Would that be faster?
Yeah, because the others, they don't hear it.
Okay, yes. Okay, so Mr. Marquez Pinto asks about the role of the state as authority on interpretation and also on the rule of law. Well, in international law, states remain the primary lawmaking actors. They are perhaps by no means the exclusive ones, but formally speaking, at least their consent is required. When I look at processes of recognition, I'm looking very often at processes of practice and opinion juris. I use the techniques and the tactics of customary law generation in order to understand how these processes are being filtered through. But to give one very brief example, the ICJ makes a pronouncement on the law of immunity or on the law of self-determination, and 2 weeks later, states are citing to that judgment at the General Assembly or in their pleadings in investment tribunals or in correspondence between themselves. That itself is a hugely important material part of how international law develops. So I hope that answers that question. Gosh, I've got so many. Okay, Mr. Musto, let's see. Nature of written language and realities of drafting process means, sorry, should I stop? I'm sorry.
I think this should be the last question because then it is,
okay.
It is now 30 minutes.
Okay, absolutely. Shall we just answer this? I'll read this question out loud and then answer it, okay? Mr. Musto asks, obviously, the nature of written language and realities of drafting processes mean some rules are more indeterminate than others, e.g. FET in the investment context. How does systemic actors' relative authority play out when the frame provided by a text is incredibly wide, to use Kelson's analogy, and interpretation is performed by numerous actors simultaneously? Thank you, Mr. Musto. My argument would be the wider the frame, the more discretion, the more space there is for the raw exercise of power, where considerations such as elite training, elite vocabulary, the ability to pay very established, very experienced lawyers in your favor helps to tip the balance in your favor. I am one of those who suggests, looking at the investment context you yourself raise, I am one of those that sees concerns in the way that some of the rules are interpreted in substance and wonder if it's not because of the nature of the rules, but the nature of the actors involved. But I've taken up my time. And so I thank Professor Westerman for the chance to answer that last question. Thank you all for your very, very rich engagement with my presentation. And I look forward to the future papers coming up just now. Thank you.
Thank you, Professor Hernández, for this magnificent presentation, and also for the very interesting questions. I think we should keep those questions and retain them, and because they're food for reflections for the other attendees as well. I haste to go over to the second speaker of today. That is Dr. Daniel Peat. He is currently assistant professor at the Hugo Grotius Center for International Legal Studies in Leiden. And Dr. Peat obtained his PhD in Cambridge and will speak about an interesting question, how we should interpret the rules of interpretation, Article 31 and 32 of the VCLT. You also deal with the topic of interpretative community. So I think let us proceed swiftly to your presentation, Daniel.
Thank you so much, Professor Westerman, and thank you to Panos and Sotirios for inviting me. So I'll try and be relatively brief in my presentation, but I do have a PowerPoint, which I suppose goes against that. Just to structure my thoughts and hopefully convey them in a slightly clearer way. So hopefully you can see my screen now. Is that right? Yes. Okay, great. So my paper is called Disciplining Rules, Compliance, the Rules of Interpretation and the Evaluative Dimension of Articles 31 and 32 of the VCLT. And in brief, the main points of my paper are the following. I'll try and go through these in the presentation. My main problematique is what I call the rule paradox. And that is that we refer to Articles 31 and 32. For the purposes of this presentation in the paper, I leave Article 33 out, although I think we could also include that, as the rules of interpretation. But what do we mean by the rules of interpretation? What is their ruleness? What character of rules do they have? And that's what I want to flesh out in this paper. To do this, I draw on Owen Fiss's idea of disciplining rules, which he developed in the 1970s. I'll say a few words about those and the criticism of disciplining rules as a concept. And then the majority of the paper looks at whether the VCLT provisions can be understood to be functioning as disciplining rules in the same vein as intended by Fiss. Finally, I'll leave with a few thoughts, which I'm still grappling with, but a few thoughts about how the VCLTs are different from disciplining rules and how they might have some character of ruleness from Fiss's concept. So let me start with explaining the rule paradox. And this was nicely set up by Professor Ruiz Fabri's keynote presentation, where she said interpretation is a rule that went for a walk. That's quite so. And in this context, obviously, we understand that the provisions of the VCLT, Articles 31 and 32, are conventional rules of international law. They're in an agreement by states in writing, and therefore that constitutes a treaty. But what really do we mean by rules in this context? And I think this is particularly important in relation to Articles 31 and 32, because this rule paradox that I'm talking about is we refer to Articles 31 and 32 as rules, yet we never really say that anyone has broken Article 31 and 32, and we never invoke their responsibility for doing so. So in what way then, apart from in this thin formalist way, in what way are they rules? So to dig into this concept, we need some idea of what ruleness is. And I don't come up with any broader theory of legal rules in my paper, but rather, happily, this has been fleshed out in the context of interpretation on the domestic level by Owen Fiss, an American legal scholar, which many of you will be familiar with. Now, Fiss was working against the backdrop of the ascendancy of the critical legal studies movement, which argued that judicial interpretation was unconstrained and just a manner in which judges or other interpreters could express their subjective views unbound. Now, he argued, Fiss, that this wasn't and shouldn't be the case, and that rules should be created if they didn't exist already, that provided objectivity to the interpretative process. Now, to provide this objectivity, he said that the states in the US or the federal legislature should enact what he called disciplining rules. And these are rules that set out how interpretation should take place. So prima facie are very much like the rules we have enshrined in the VCLT provisions. And Fish said that these serve two functions, which he doesn't use these terms, but I've termed them in the paper, the directive and evaluative functions. So the first one is that they guide the interpreter. They direct the interpreter to how to make an interpretation, what process to go through. Now, the evaluative function is something different, and that's they provide the benchmark by which an interpretation can be assessed by a third party, and they provide grounds for justifiable criticism of that interpretation. And his words, and I quote here, "Objectivity connotes standards, implies that interpretation can be measured against a set of norms that transcend the particular vantage point of the person offering the interpretation. Objectivity implies that interpretation can be judged by something other than one's own notions of correctness. It imparts a notion of responsibility. The idea of an objective interpretation does not require that interpretation be wholly determined by some source external to the judge, but only that it be constrained." Now, as many of you that have read about interpretation and theory before know, Fisher's notion of disciplining rules was contentious and came under attack, most notably by literary theorist Stanley Fish, which resulted in a well-known exchange in the literature. Now, Fish criticized this on two grounds, disciplining rules on two grounds. The first was that disciplining rules just aren't needed, that an interpreter doesn't have the kind of flexibility and discretion that Fish said they had, and for which he came up with the concept of disciplining rules to counter. Fish says that interpreters always work in a context, historical, social, professional context, and that provides a constraint on interpretation that obviates the need for any kind of disciplining rules. Now, I think this is a bit overstated because sometimes interpreters that operate in very similar contexts with very similar backgrounds come to different conclusions regarding interpretation. And I think a nice illustrative example on the international level are the decisions by international investment tribunals regarding the interpretation of Article 11 of the US-Argentina BIT. I go into that in a bit more depth in the paper. And the second criticism, which is perhaps more relevant to the VCLT rules, is that even if you had disciplining rules, those rules would be texts and they would be subject to interpretation themselves. So they cannot constrain themselves. Now, Fish recognized this, but argued that interpretive ambiguities could be resolved by reference to norms that he refers to as being higher along or higher up the spiral of reasoning. In this context, Fish seems to have in mind written norms, but I think also social norms, social conventions could serve this function, and they need not be necessarily higher order insofar as that means broader or more general. So think, for example, of the convention that we can refer to ILC debates in the context of the travaux preparatoires of a treaty, if the ILC work led to the conference which that treaty was concluded. This neither comes from the text of the VCLT provisions, nor from a higher order norm, but rather from the practice of the actors themselves. So in the paper, I go into two ways of exploring whether the VCLT rules operate as disciplining rules. The first is a historical perspective. In the interest of time, I'm going to be quite brief here. I look at the debates in the Institut de Droit International, the ILC, and then the Vienna Conference. And although these debates are normally understood as and characterized as being a battle between subjectivists and textualists, when you look at what the main actors understood the rules to be doing, it's clear actually they were all on the same page. They were not understood to dictate or even privilege any particular kind of interpretive methodology. But is also interesting to mention is this kind of raises the question, why would these rules be put in the convention if they were understood not to determine any kind of interpretive methodology? And the reason is the drafters quite simply thought that if you were going to have a law on a treaty on the law of treaties, that there needed to be some kind of provisions on treaty interpretation, that they had a rightful place in this kind of project. So on the slide behind me, I have a quote from Waldeck's Sixth Report in 1966, which nicely sums up the discussions. Waldeck was characterized as being a textualist in these debates, which I don't think is particularly true. But this nicely sums up his summary of the position of the Commission members, which was the Commission was fully conscious of the undesirability, if not impossibility, of confining the process of interpretation within rigid rules. And the provisions of the 1964 draft articles, which with a few amendments then became Articles 31 to 33 of the Vienna Convention, together do not appear to constitute a code of rules incompatible with the requisite degree of flexibility. So when we look at the origins of the VCLT provision, there's not the idea that the VCLT rules served the directive or evaluative functions that FIS considered disciplining rules should function. But when we look at the practice of courts and tribunals now, it's a little less clear that they serve no function at all. So in the paper, I take the example of Argentina's proposed interpretation of Article 54 of the ICSID Convention. And I look at two decisions of ad hoc annulment committees on Argentina's requested stay of enforcement of the award. And this is important because those committees engage with Argentina's proposed interpretation of Article 54. And what I'm concerned with is not so much whether that interpretation was correct or incorrect, but rather whether these committees use the VCLT provisions as an evaluative benchmark. Do they have this evaluative function that FIS said disciplining rules should have? And in short, they don't. They acknowledge Argentina's interpretation, and then they quite simply go and interpret the provision of the convention themselves with reference to the VCLT provisions. But what they don't do is say that Argentina's understanding of ordinary meaning or context is wrong, or that Argentina doesn't give correct weight to the intention of the drafters, or that it didn't adopt the correct hierarchy in terms of the elements of Article 31. To my mind, this says that the benchmark of Article 31 isn't used as a kind of a way of evaluating an actor's interpretation. It's used as something different, at least not in a conception that FIS intended it to. So I'm getting to the end of my time. Let me leave with a few thoughts. I conclude the paper with what I call, I suppose, the second rule paradox, and that's, although the VCLT provisions don't seem to serve the directive or evaluative functions, we have the paradox of them being nevertheless consistently referred to by courts and tribunals and by all other actors in interpretation. And I think there's 2 points that are relevant here. One is that although the rules don't have what we might call a thick evaluative dimension or directive function, they don't determine any particular interpretive methodology. They have what we might call a thin evaluative dimension, and that's that they circumscribe the kind of outer bounds of what are acceptable interpretations. So we can't just neglect the text of a treaty in a free-ranging search for the intention of a drafter. I think as well, what's important to understand is that this was different, the intellectual context in which FIS's concept of disciplining rules were developed is different from the intellectual context in which the ILC's work on what would become Articles 31 and 32 of the Vienna Convention was developed. FIS was going against the CLS movement, which, in order to have a convincing counter-argument, he needed to promote objectivity in interpretation. The ILC was going against Myers-McDougall and the New Haven schools argument that the intention of the drafters should be the thing that should be given priority. So objectivity of interpretation is not really required in order to counter that. I'm a bit concerned that I'm running to the end of my time. So I'll wrap up there and I look forward to your questions and comments.
Okay, thank you very much, Dr. Peat, for your this surprising refutation of the two functions of the rules. There is a question by Vladislav Lanovoy. The disciplining character is rarely in the mindset of judges as an objective in of itself. In practice, courts and tribunals often prioritize certain elements over the others, including the ways in which they give priority to the text over the object, or vice versa. They often refer to certain elements without expressly associating them with a specific paragraph or alinea. So I guess, where is the discipline to it? Well, of course, you also refuted this disciplining character. So yeah, but maybe you can react.
Yeah, no, I agree with Vlad's point. I think perhaps what's important to bear in mind is that when Fisk came up with these arguments and his idea with disciplining rules, his idea was, I think, not necessarily that it would always, I suppose, consciously be something that structured and constrained the interpreter's interpretation. He also recognized that if it was a disciplining rule that was ingrained in, and going back to the idea of interpretive community, it's actually a slightly different conception of interpretive community to the one that's common in international law now. So the interpretive community as understood by FIS, which is actually from where Ian Johnston in the early 1990s drew the concept and brought it into the international law scholarship. FIS's conception of interpretive community is more narrow, and it's that an interpretive community is necessary to recognize the disciplining rules as providing objectivity to interpretation. So it's not that an interpretive community recognizes particularly interpretive arguments as being more convincing. So trade lawyers recognize textual arguments or arguments providing more stability and predictability as being more convincing than others. Really, FIS's conception was limited to recognition of the disciplining rules. So going back to Vlad's point, I think this recognition by the interpretive community meant that it could constrain the interpreter without necessarily, essentially subconsciously, without necessarily being made express. So I think the fact that, as Vlad said, the courts and tribunals don't necessarily refer to particular alineas of Articles 31 and 32 doesn't mean that they don't play a role in, well, the argument would go, as I said, I've refuted it, but they wouldn't play a role in structuring how they approach interpretation.
Mm-hmm. Thank you. There is a question of André de Hoog, a very short one. Can the disciplining character of the rules of interpretation of treaties perhaps be defined in the interpretive academic community? I'm not sure about this defined. Is this?
Yes. So perhaps if I understand Andre correctly, it's that are they used by the academic interpretive community as benchmarks against which we can assess correct interpretation or not? This is something, so I don't deal with the academic community in itself, but it's something I go into in the paper in a bit more depth. And in relation to Fish's second criticism of Fish's disciplining rules, that's that the rules need interpretation. I think the VCLT rules also need interpretation, and the extent to which conventional practice, so conventional as in social conventions as opposed to treaties, sorts out the ambiguities in the rules of the Vienna Convention. I'm not sure it does absolutely. In fact, I'm relatively sure it doesn't. So to that extent, I'm not sure that even within the academic community, the VCLT provisions serve the disciplining functions and the evaluative function intended by FIS.
Okay, someone else? No? Someone of the panel, Panos. Oh, now there's, okay, Panos raised his hand earlier. Okay.
Thanks, Pauline. Dan, thank you very much for the great presentation. And we've had the opportunity to discuss this several times and disagree on a number of topics. One thing that I wanted to ask you is with respect to this argument, this criticism of the infinite regress. So my thoughts on this is that this is really not a problem because, first of all, the infinite regress argument kind of takes as a given that self-referential kind of systems or statements are automatically problematic, which is not always the case. So you kind of think immediately of self-defeating, like the barber who cannot cut his hair by himself. But not all self-referential statements are like that. And I mean, you could think of, let's say, from mathematics, fractal images where you can go infinitely, depending on how much you want, into depth and logarithmic kind of quantities. But the other thing is also, I mean, even with the VCLT, the infinite regress that you apply the rules to themselves and then again, I'm not sure that it does apply, because first you would have the VCLT rules, then in order to interpret those, you would use customary international law. So you've already switched to a different source. You might interpret those customary rules, or you might go to general principles. So you hop from one source to another. But at the end of the day, you'll end up with an issue of pedigree. So then my question is, isn't this really what is at issue? So a question of pedigree rather than of self-referentiality.
So yeah, thank you, Panos. I'll sort of sidestep the question by saying that what I'm concerned with in this paper is trying to understand how their rules, over and above just being treaty rules, what's their ruleness, and I don't think that the sort of the question of pedigree really fits within and reference to other customary rules that are in turn very much reflective, if not identical, to the VCLT rules. I don't think that is what FIS had in mind when he understood, or when he countered Fish's criticism of disciplining rules. So I think I agree, potentially it's not always a problem, but I think at least if we want to understand the ruleness of the VCLT rules in this context, it does put a roadblock on understanding them as disciplining rules in this narrow conception of what FIS meant.
Thank you for this answer. I just want to draw your attention to the question by Johan Hatting. Could Articles 31 and 32 have a disciplining effect in the sense that they require a justification from an interpreter with reference to them? This could be relevant in domestic courts where, for instance, decision makers don't have a culture of justification.
Yeah, that's an interesting point. And it goes to the point that I didn't really have time to cover on the concluding thought slide, which was, why are these rules referred to in judgments and awards if they don't have this disciplining effect? I think perhaps the most convincing explanation is, as has been alluded to already in the keynote and by Gleider, is it shows membership of a particular community. And I don't want to use the word interpretive community because in the paper I use interpretive community in the narrower conception of the term. And that I think has a lot to do with both, I suppose, sociological explanations, and that in the final paper I'll kind of explain, but also cognitive explanations, wanting to maintain membership of an in-group and to avoid the kind of cognitive discomfort that comes from, in this case, not justifying interpretation, using the correct terminology.
Okay. I think we have time now for the last question, also again by André de Hoog as a follow-up comment, because he has had time to think about your answer and now comes back with the appellate body of the WTO does appear to use the disciplining character of the rules of interpretation in order to direct the interpretive process engaged in by panels. Maybe you can react on this, and that should be the final question.
No, it's a very good point, because I think it nicely shows how I think the appellate body and the WTO, as we all know, is a really particular example because they are, you know, the panels and the appellate body, perhaps the only institutions to take such a hierarchical approach to the VCLT rules. And I agree that if that was more widespread, if there was a kind of conventional acceptance that that was how the VCLT rules should be interpreted and applied, then they might well have this disciplining function, because it would be, as Fis said, in essence, the kind of higher order norm by recourse to which interpretation of the disciplining rules themselves was resolved. The problem is they don't. The appellate body and the panels are very much kind of alone in taking such a consistently hierarchical approach to interpretation. So perhaps if we look at the microcosm of the VCLT rules, or I suppose it would be more Article 3.2 of the DSU as a disciplining rule, we could say maybe that's a disciplining rule, but the VCLT provisions themselves, I still don't think have that characteristic.
Thank you so much for these answers. I'm certain that there will be more questions, then maybe you should address them individually or later by email. I want to thank you so much then again for this presentation and for all your questions. Then we move on to the organizer, one of the organizers of this conference, Professor Sotirios, Dr. Sotirios Lekkas, who obtained his PhD in Oxford and is well known now as a postdoctoral researcher attached to the TRICI project of the ESC project that is the framework of this conference. And Dr. Lekkas deals with the question I thought is a very intriguing one, into the status and the weight of the guidelines and conclusions of the ILC, the International Law Commission. So Sotirios, please enlighten us on this rather puzzling question. I give you the floor.
So let me just, yes. Thank you, Pauline, very much for your kind introduction. Now, my approach is a bit more heuristic. Let's say I'm trying to figure out these overarching questions more by reference to by reference to what actually is going to happen or happens, and I use a case study to do that. So specifically, I focus on the uses of the works of the International Law Commission in international adjudication. So a few words about the profile of the study. The ILC, in a nutshell, for those who might have not heard of the ILC, is a legal body, is a body of legal experts constituted by the General Assembly and tasked with the progressive development of international law and its codification. Its legal basis is the UN Charter and UN General Assembly resolution. Now, this body of legal experts actually deliberates, and its outputs are quite diverse, both from an internal perspective, So there are a multitude of material produced during the consideration of the topic by the ILC. Questions like the law of treaties or the law of responsibility has been discussed for decades. So there is a multitude of material there, and there's also a multitude of designations by the ILC of its final works. You have draft conclusions, draft articles, draft principles, guides to practice or whatever. And it is also, and there is also an external perspective. So you might have ILC works who lead to the adoption of a treaty or not, and might and are, do not have a particular form. So in terms of formal sources, what we do know is that, well, most authorities would say that ILC works are teaching of the most highly qualified publicists, or in any case, they're just subsidiary means for the determination of rules. And there is no differentiation amongst this internal and external perspective to a large extent. Everything is pretty much the same. But as material sources of international law, and this goes to the ways we identify or determine the content of rules of international law, they might have a differentiated approach. So this paper focuses on the practice of international courts and tribunals when they use these ILC works. And it asks two questions. Do international courts and tribunals actually justify their use of those works by reference to the formal doctrine of sources of international law? And the second is, how do they deal when those materials actually are ambiguous themselves? How do they deal with that? So, as you will see, the whole idea here is to try to draw a bridge between this general idea of authority and the formal theory of sources of international law. Just an iteration, just an instantiation of that thing, just heuristically. How do they do it? Now, the first thing and the most common ways in which international courts and tribunals, or the most common context that international courts and tribunals actually refer to ILC works, is the context of treaty interpretation. More often than not, we focus on the footholds of in the rule of treaty interpretation to use ILC works in this formalized process. But the point here is also that there is a methodology for the use of ILC works, which is implied by the rule of interpretation. So more specifically, how do they usually justify their recourse? First of all, with respect to treaties originating from ILC drafts, like the Vienna Convention on the Law of the Treaties itself, usually, overwhelmingly, they call it preparatory works. Even though they do not directly emanate from state parties or from their negotiations, they nonetheless have a supplementary function to confirm an interpretation that has been reached by other means, or to clarify an interpretation that cannot be clarified with the use of other means. In other cases, we see, again, an additional value to ILC works. So in the jurisdictional immunities case, or in the Kasikili-Sedudu case, the court did not refer to any other thing. It directly referred to the ILC commentary, and it merely stated that, well, the ILC, the VCLT, for example, uses this term, the ILC said this, so it is clear that this term means exactly what the ILC said. Now, to rationalize this or to justify this, one can do this by reference to the rule of interpretation again, even though courts do not do that so often. So one can refer back to Article 31(2)(a) of the VCLT or Article 31(4), and argue that the party's stance towards the ILC output implies an agreement of the parties with respect to the interpretation given by the ILC. So there, constructively, you can find some connection. With respect to other ILC outputs, also there are footholds in the law of interpretation. Again, they can be used as supplementary means for the interpretation as in pari materia instruments. So for instance, even though the ICC statute does not originate directly from the 1996 draft code, which is an ILC work, because the ILC at the same time deliberated on specifically the statute of the ICC court, trial chambers tend to refer to that instrument, the 1996 draft code, because according to it, well, drafters should have been aware of the terminology used by that instrument. Again, in other instances, courts might use other ILC outputs for different reasons. For example, determine the ordinary meaning or the object and purpose of a treaty. So with respect, this was most prominently the case with the International Court of Justice in the Bosnia genocide case, where the court referred directly again to the ILC draft code to determine, to come up with an interpretation according to the object and purpose of the treaty, the Genocide Convention, and how to construe the definition of genocide in that case. Or even the context, to the extent that we can consider them as emanations of other relevant rules of international law. As we will see, this is quite often. So there are some footholds. The less conspicuous aspect of it is that they also imply a methodology for the use of these works in the context of interpretation, to the extent that we aim to establish the intention of the parties. So this implies a schedule, a proximity sort of test. There is more value to the work which enjoys the state's party's approbation, either because it is more proximate to the treaty or because it has been accepted by the United Nations General Assembly, and so on. Conversing materials reflecting the personal views of members of the Commission, earlier views of the Commission, or even comments of individual states towards earlier drafts of that Commission are accorded a lesser role, even if they are parties to the treaty that we are trying to interpret. So we see there that there are the rules of treaty interpretation can function as a guide, as a guide for how to use them in practice. And occasionally courts use this terminology. Now, let's turn to rules of unwritten international law. And first of all, customary international law. So the traditional label of teachings actually implies again that there is no differentiation at all. And also implies no specific role, only a subsidiary role in the determination of customary international law. However, both the ILC, which was ambivalent with respect to that label, and also practice does not support this label of teachings. There is only one decision out of hundreds of decisions that explicitly uses this characterization. The ILC, perhaps in a self-referential manner, has said that the weight to be given to the Commission's determination in the context of identification differs and depends on different factors, including the sources they rely upon, or the stage reached in the work of the Commission, or above all, the state's reception of its output. This is where the ambiguity lies, because the evidence or the stage reached in its work still speaks of its value as a scholarly work. The key point here is the reception, the state's reception of its outputs, and in this respect, the ILC works in principle could constitute evidence of opinio juris. So this is most evident in the North Sea Continental Shelf case, but in other cases which relate to the relation between treaties and custom, where occasionally courts refer to works of the ILC in order to determine whether a treaty provision codifies custom, or the negotiation or conclusion of treaties has led to the crystallization of a customary law. But this is not exactly what happens in practice. There are, of course, these judgments like the North Sea continental shelf, but in practice, what we see is that decisive weight is accorded to works of the ILC, so that the ILC's normative proposition is identical with the content of the rule of customary international law, and courts tend to justify that on more or less familiar ways. So they mostly do generic reference. Some of them do generic references to the evidence they rely upon. Others refer to the mandate of the ILC to progressively develop or codify international law and the thoroughness of its processes. Others opt for a more formal justification. They invoke the subsequent reception in the practice of states, including the subsequent General Assembly action. Whereas others are, these justifications are not easily explicable. So they either rely on the pronouncements of other courts, that an ILC provision or proposition reflects custom, or they rely on the stance of the parties to the dispute towards that ILC proposition. Now, examples are spread through all courts, but I have given examples from, in relation to its justification, from only one court. So, and perhaps the most agnostic one, I reserve this to the International Court of Justice. But the point here is that this issue of decisive weight. Now, turning to the other source of unwritten international law, ILC works, the use of ILC works in international practice can also be used by reference to general principles of law. Now, this issue is under consideration by the ILC itself at the moment. There are many open questions. The only reason I'm raising this is because the practice of international courts and tribunals suggests that certain ILC propositions are that the use of certain ILC propositions is grounded on the assumption that they are generally recognized in domestic legal systems, but courts rarely, if ever, engage in any independent examination of these of the constituent elements of general principles of law. The point here is that they can be that general principles of law can be used as another justification. Now, also the open questions actually that exist with respect to the identification of general principles of law also, to a certain extent, are mirrored in the use of ILC works. So specifically, now the Special Rapporteur on General Principles of Law, in developing the conclusions, has made no specific consideration of ILC works. So they probably fall under the rubric of outcomes of public codifications initiatives or as teachings. But one can construct another justification, which is more or less analogous to the conclusion of relating to customary international law, but apply with more force in the case of general principles of law, because the composition of the ILC is practically the most appropriate in order to determine whether a principle is recognized by general legal systems of the world. It is right there in the ILC statute. Also, the operation of transposition, that is a constitutive element of general principles of law, is an essentially deductive operation. So essentially, the ILC comprised of jurists must be a better place to do that. But in any case, the subsequent actions of states can also imply recognition by the principal legal systems of the world, in the sense that states recognize the existence of certain principles intrinsically legal in nature. In any case, however you construe it, the point here is that in practice, very often, courts tend to rely on ILC propositions as articulations of applicable rules of unwritten law. And the question that arises is, how do they do it, and how do they deal with their ambiguities? Now, generally, the way that they deal with these ambiguities is in a way that they would do if they were dealing with a treaty. They refer to the text of the articles, their context, their object and purpose. The only difference is whose intention, essentially. It is not the intention of the ILC, it is the intention of the parties. But this is also reflected to the means they use to implement this overarching consideration. So whenever there is a discrepancy between the ILC draft positions and their commentary, they give preference to the provision. There are some examples, I won't elaborate on that. And also whenever there are discrepancies between the final output and the materials produced during their preparation, they give priority to the final output. Now, the final question is whether this heuristic actually has certain, credence in international law. The issue of ruleness has been already raised. Very briefly, apart from general normative consideration of impartiality or non-arbitrariness, which have been already explained, my sense is that another argument in favor of ruleness, so that this practice constitutes evidence of ruleness of interpretation, is also that it enables the review of judicial decisions when it is provided. It is not only annulment proceedings under Article 52 of the ICSID Convention or appellate or quasi-appellate review by international criminal courts or the WTO, or even between the section and the grand chambers of the European Court of Human Rights. It can also be in the sense of judicial dialogue, interjudicial dialogue, or even in the context of implementation of international law in domestic courts. Now, there are footholds within the ILC's works on the identification of customary international law and general principles of law for this notion of interpretation. And as to specific instantiations of such rules, at the moment I only have examples from investment tribunals, either they refer explicitly to a rule, so a panel actually referred to the principle of good faith to interpret the customary rule on the exhaustion of local remedies, or they actually annul an award of a panel on the basis that it disregarded applicable rules of international law. This is one way to understand the Enrodel movement. So in this case, the tribunal found that it was necessarily required for the tribunal to either expressly or sub silentio decide or assume the correct interpretation. But in order to do so, it needed to apply something. Otherwise, there would be no correct interpretation.
Sotirios,
so
because following your own instructions, I should now say, well, stop, but okay.
I'm really sorry.
As
the
organizer.
So to conclude, there is no singular category to classify ILC works in indeterminations of rules of applicable rules, but their function differs. And well, whereas the rule of treaty interpretation provides a blueprint, the context of identification of rules of unwritten international law is not adequate. However, the relevant practice can constitute evidence of existing or emerging rules or principles for the interpretation of unwritten international law. Thanks so much for your attention.
Against your own
and for giving me some extra time.
Thank you so much, Sotirios, for this really intriguing presentation. I liked it very much. Maybe you can stop sharing the screen, because then, well, we can see only the panelists, but nevertheless, then we see the panelists. Is there anyone in the audience or the attendees who would like to comment or raise questions? It always takes some time before the audience is somehow wakes up to the occasion. This is Helene Ruiz-Fauri.
Yes, thank you. Thank you for this fascinating presentation. I agree with what you said. What I find very striking, nevertheless, is that the Commission is composed of 34 experts coming, or so-called experts coming from all over the world. And so what comes into the reports of the ILC is already the outcome of a negotiation among a certain number of people, very diverse people. And you can see this also by comparing the reports when you have special rapporteurs and the reports of the ILC itself. So I was just wondering, because I saw this for, I studied more closely the reports on use Cogens, and there I could see them in the discrepancies were rather striking, and it was a whole conservative move, obviously, and meaning that the ILC was far more cautious than the reporter, who was already very cautious because it was a minefield. Everybody was aware. And so I just wondered whether we could not consider that it reinforced the authority of what the ILC says, because it has already been polished, if I can put it like that. For the rest, I agree that we also have a problem of temporality, probably, because the ILC on the one hand is seizing very controversial topics like customary law, treaties over time, general principles of law, all topics on which we know it's impossible to come with definite answers. It can come with somehow a political agenda, like was the case for the report on international customary law. And so, and it's the same in the Use Cogens report, that it's very focused on the idea of putting at the forefront state practice, and state practice with this paradox that you say that state practice should be considered first, but the voice you listen to reflect on state practice is the judge voice. And it's always stated to be subsidiary, and at the same time, it's the one put at the forefront, because it is there that you find, I would say, a reasoned statement or explanation about what the so-called state practice, whereas we know that it's already an interpretation. So I wanted to have your feeling about that, and whether maybe your conclusion was a bit too harsh on the authority of the ILC, although I can see all the reasons you had to reach such a conclusion.
Thank you very much. It's a very interesting question. Sotirios.
Many thanks for Professor Ruiz-Fabri for the question. Actually, the whole idea behind it is more or less, so as I said in my introduction, it's more or less of a heuristic approach. I understand that there are certain points you have raised which are essentially true, yes. So in terms of the political agenda of its members, or the political nature of the ILC outputs, that is absolutely correct. However, the idea here, and perhaps, and also the political nature of international judiciary as well, the idea here is to understand whether there is within the international judiciary who have to justify, they have the, let's say, the incentive to justify their decision, whether there is something more to it. And by something more, I mean not how to upgrade the authority of the ILC. The ILC already, as you have explained, has a lot of authority. The issue here is how to rationalize and operationalize this sort of idea of authority in legal terms and in terms that international judges can use. With respect to use Cogens, the draft on use Cogens, I understand that there is the problem now with ILC's own views is this sort of chilling effect on issues which might need further policing and further consideration. So, for example, one can say that of course, the success story of the Vienna Convention on the Law of Treaties and the more unexpected success story of the articles on state responsibility actually had a chilling effect on an issue which had its own independent, let's say, value, which is use cogens. So the ILC became a prisoner of its own success. Well, this is what we already have agreed. Well, the special rapporteur, well learned as he is, has great views, but we feel that neither the Sixth Committee nor the General Assembly would like to deal with this issue again. So I understand what you are saying, and essentially, one could also, to the extent that the General Assembly actually wants things to move forward, it has ways to do it. That is maybe the political aspect to it. Hope this answered your question.
Thank you. There is another question. I have to move on because I see at your face, Professor Ruiz, that you want to comment on this. But, well, nevertheless, there is a question of Nikolaus Vulgaris. Which of the different justifications utilized by international courts with respect to the normative quality of ILC outputs do you find more convincing? Which of the different justifications do you find more convincing?
Well, that depends on the circumstances, doesn't it? So the issue here is not what justification I find more convincing. The issue is what justification actually has, is actually used in practice. So in terms of, my feeling is that that's why issues of identification of rules and interpretation of rules are becoming increasingly more, let's say, more heuristically approached, and they are trying to lay down specific rules, guidelines, principles in order to resolve this idea, to resolve this issue about convincingness of a specific justification. My answer to that is it depends on the circumstances, it depends on the rule, and of course the outcome.
One final question by myself. What do you exactly mean by heuristic? I mean, there is a heuristic function of, for instance, rules, but what is the heuristic?
That we are trying to understand more the methodology or the practice and try to systematize the practice rather than, and maybe fill the gap of the practices with suggestions. But the idea here is to more and more to amass sort of the practice of justification and interpretation rather than, not evaluate. Yeah.
What Professor Hernández called the process.
Yeah.
Okay. Well, exactly 1.5 hours later, we have reached the natural, but natural in the, not in the French, but in the English sense of the word, a natural point of ending our discussion, the panel discussion. I think we should be very truthful to the schedule, because this Zooming can be quite fatiguing, and we should have our spare half hours together with a nice box provided by the organization. And we should go outside and have a fresh air of breath. Thank you so much for, I think I hugely enjoyed the presentations of this first panel. I have to leave now because unfortunately I was so stupid as to plan other meetings, but I hope that the rest of the day will be just as interesting as this morning. And thank you for speaking and for answering the questions, for putting the questions, and have a nice short break of 25 minutes of Zoom-free space. Thank you so much.